There are two copyrights vital to the music business, protecting every recorded song. We have the musical composition, or the song, which includes the lyrics and the music. We have the copyright in the sound recording, which is the actual recorded performance of a particular musical composition. Sound recordings were not protected at all by federal copyright law until 1972. But that didn't mean they were tossed into the public domain. That just meant their protection was found somewhere else, which was deemed under state law. But that changed in 2018 when President Trump signed into law the Music Modernization Act, which gave federal copyright law protection to pre-1972 sound recordings. And I'll get to this in a little bit more detail in a minute. The sound recordings, they embody the musical composition. So we have, for example, Taylor Swift. She wrote the song Bad Blood. She owns the copyright in the musical composition. She may have given it to a publisher or had some deal with a publisher, but for the sake of simplicity, she wrote it, she owns it, the musical composition. She also recorded it, and it's a track on one of her albums. And as the creator-author, she technically owns the recording. However, per her record contract, she's a work for hire, and that's required, and she's required under that to assign it over to her label, so technically a record label, who then reproduces it and distributes it, is the owner of the sound recording. But because of that, she still gets paid for each and every song that she wrote, and we're talking about Bad Blood, but as the musical composition, she still gets paid for every copy of that goes out. So, recap, Taylor Swift owns the song Bad Blood. She wrote it, musical composition. She recorded it, and as an author, creator of the recording, technically she owns it, but she gave it away to her record label, who is then now the owner. A few years later, Ryan Adams also recorded Bad Blood, and that track is on his album. And let's say he just did it on his own. There's no record label. He did it on his own. Can he record Taylor's song without her permission? Yes. If you remember, under the limitations or limited exclusive, there's some limitations to the exclusive rights. He can obtain a compulsory license. That's one of the limits on the exclusive rights. As long as the original owner got to choose who did the first recording, which she did. It was hers. So he can do that without her permission as long as he goes and gets the compulsory license. If he wishes to perform the song at his concert, let's say, that's a whole nother issue that comes under performing rights. So let's talk about how each of these works are protected. Owners of a musical composition. They enjoy the protections of the statutory rights, as we discussed last week, subject to the first sale doctrine and a few other restrictions, just like the one I just described above with the compulsory license. Owners of sound recordings have exclusive rights, but there are limitations on the scope of those rights. They're actually more narrow, and we've already touched on them, but let's review. First, sound recordings were not protected until federal law until 1972. Musical compositions have been protected since 1831. Therefore, those sound recordings are protected, or were those pre-1972 sound recordings were only protected by state law, and the states that have addressed this issue of copyrights in pre-1972 sound recordings said that copyrights in sound recordings were only extended to present reproduction and distribution issues. So that's all that those who owned copyrights in pre-1972 sound recordings had were rights regarding reproduction and distribution. There was no general right of public performance for sound recording under either law, federal or state law. So what that meant was that with no public performance right to enforce, radio stations could play the songs without paying a fee. There were, and there are, recordings in these recordings, they are required to pay a license fee for the underlying musical composition. So every time a radio station plays a song, the sound recording, they don't have to pay anybody for the sound recording, but they do have to pay a fee for playing it per the musical composition. So every time Taylor Swift's Bad Blood song gets played, she earns something. If it's played on a radio station somewhere, it gets paid something. And licensing organizations are tasked with collecting these fees. ASCAP, BMI are the two primary ones. With the creation and the passing of the Music Modernization Act, that changed things a bit for the pre-1972 recordings, in that now sound recording copyright owners have been afforded a limited public performance right that covers public performances made via digital audio transmission. This has also been extended for post-1972 sound recordings as well. And now they get the protection under federal law. The other limitation on sound recordings, as we discussed last week, but it's worth a recap, is on the exclusive right of reproduction. With all other types of works, the copying of a work is much more than just a literal copy. It can be non-literal copying, such as capturing the expression. We've talked about that. However, the reproduction right of a sound recording is limited to the right to duplicate the sound recording in the form of phonorecords or copies that directly or indirectly recapture the actual sounds fixed in the recording. So, literal copying only. Sound-alikes are okay. How else do we get cover songs? Has to be a literal copying. So let's take an example. A young guitarist loves Slash in the Guns N' Roses song Sweet Child of Mine. He borrows, quote unquote, borrows the main riff from the song and the chorus and includes them in a new song he writes. Can he legally do that? No. Guns N' Roses, as the writer of the song, controls the right to prevent others from using part of the song. This would constitute copying the musical composition. And it also derivative, in making an entire another work with that material in it. So there's two rights that have been violated relative to the musical composition. The copying, reproduction, and the derivative. This does not infringe the sound recording. Why? Because it's merely a sound-alike. It's not the actual copying. Can you sell your iTunes files? Joe buys a copy of Adele's Hello from the iTunes music store. Joe later decides to sell his soft copy he tries to sell his copy to Janet Williams, his friend Janet Williams. Can he do this? Theoretically, under the first sale doctrine, Joe can sell his copy, but he'll have to delete his copy. However, if you think about it, it would be impossible for Joe to actually give his file to Janet without also giving her his device on which the song was loaded, because a copy would be necessary. Even if Joe deletes the song from his computer as soon as he's sent the file to Janet, he has still infringed the right of the copyright holder to restrict copying of the work. It is impossible to transfer a file to another without first making a new copy of it before deleting the original. So, this is a tricky point. I brought it up before. So with sound recordings, you need straight up copying of a sound recording, which leads me into the next important topic regarding the use of soundings, and that is sampling. I don't know how I did not flick my last slide. I'm sorry about that. I already just broke down the owner musical composition rights and the owner of the sound rights. Sampling is what I want to talk about now. If you take the exact piece of recording and put it into another sound recording, is it copying? Sounds like it when I say literal, right? Literal copying. You take the same exact piece, portion of that piece. But what if you change it up a bit or modify it? What if you only use a small segment or a note or 2 notes and you modify even that? What if you change it up? You slow it down, you slow down the tempo. You add another little hi-hat, another beat. Sampling is defined as copying and remixing sounds from previous sound recordings and using those, often significantly altered, in new recordings. Is this new work a derivative? So from here, I'm going to point out there is in the assignment, I'm asking you to watch a documentary on sampling, Copyright Criminals. It explains how this law has developed in its background. You may be already aware of the fact that you can't sample. This law's been around for the last, 10, I think this all kind of started in the early 90s. And I know many of you are familiar with the famous cases because I saw them in the database posts, the Vanilla Ice and the Queen lawsuit, the police and P. Diddy lawsuit. Katy Perry was recently involved in a lawsuit, as was Led Zeppelin with Stairway to Heaven. And we're going to talk more about those lawsuits when we talk about infringement. But they were using parts of songs that already existed. So I want you to watch that as part of the assignment so you can get the background on sampling and how it brought it to the light and why it's illegal to sample, or it's infringement to sample, and depending on how you use the infringement is whether you just owe money to somebody or whether it can be criminal. But an extension of sampling, and I'll go back to the question I asked earlier, can you just take a note or two? If you know some of those songs, they take a lot of the piece of the song. Say, for instance, Led Zeppelin, the Stairway to Heaven song, or Police, Every Breath You Take, and P. Diddy's remake song. You can really tell that they've taken the song, or Vanilla Ice and Queen, Ice Ice Baby, and Under Pressure. But what if you just take a note or 2 and then you modify it? It isn't even recognizable to most people, and you use it without the copyright owner's permission. This little bit of work can be described as de minimis, but in the court's eyes, something is de minimis only if the average audience would not recognize the appropriation, meaning recognize that it was taken from somewhere else without the other person's permission. Courts have made clear that samples that appropriate de minimis segments of protected material from copyrighted musical compositions, that's the lyrics, and the music, are not actionable. It's not infringement. They're not protected because they're deemed de minimis. But courts have disagreed over whether this de minimis limitation applies to copyright infringement claims involving samples that are brought by the owner of sound recordings, taking the actual sound recording. And there are 3 cases. Below this lecture are 3 videos related to these cases. I lined them up in order as I talk about them. They're only a few minutes long. I ask you to review those after listening to reviewing this lecture. So the cases are Bridgeport Music and Dimension Films. Bridgeport Music and Westbound Music, they are our plaintiffs, own the copyrights of the musical composition and sound recordings. Bridgeport Music owned the musical composition. Westbound owned the sound recording relative to a George Clinton song. And in the video, you'll hear the 2 songs, and you'll hear the explanation in the case. A 4-second long 3-note sample from the song was taken and used in a tape loop for a rap song that was included in the soundtrack of a movie owned by Dimension Films. Dimension had gotten Bridgeport's license, that's the musical composition folks, but did not have a license from Westbound, who were the sound recording owner folks. So Westbound sued Dimension for copyright infringement. The first court that heard the case found for the movie company, and Westbound, the sound recording owner, appealed. The trial court had agreed that Dimension had used the sample without permission, but that it was just a de minimis use. Small undertaking, not recognized by an audience. But the appellate court, when the loser went to the appellate court to say, hey, review this issue, the appellate court found that the defense of de minimis use should not be allowed when the defendant has not disputed that it digitally sampled a copyright sound recording. Like they admitted to it. They said, we used it. We didn't use it. And the court said, no, you knew you were using it. You said you were using it. You're not disputing that. So the sample, your use of the sample is copyright infringement. The court further found that the law, the Copyright Act, clearly gives the copyright holder the exclusive right to prepare derivative works. So they considered it a derivative. And the court distinguished the case from the next case we're going to talk about, in that the infringer had a license in the old case for the sound recording, but not in the underlying musical composition. We'll talk about that up next. But in this case, Dimension had a license to the underlying composition, but not the sound recording. So the court found that the difference was that it was very easy to prove that someone sampled an actual sound recording, because it's a literal copying, regardless of how big it was. So that's the first case on the issue. Second case on the issue involves the Beastie Boys. Newton was a jazz musician who composed and recorded a song, and the video, side note, the video that goes along with this will also play you the two songs that we're talking about and the clips. He sold the rights to the sound recording to ECM. However, he retained the rights to the composition. So the jazz musician owns the musical composition. Years later, the Beastie Boys, who's represented by Diamond, sampled 3 notes from Newton's song and used them in a tape loop for one of their songs. Diamond got the rights to the sound recording from ECM, but did not get any rights from Newton. Newton owns the musical composition. Newton sued for copyright infringement. The trial court found for the Beastie Boys, and the jazz musician Newton, he appealed. The trial court found that a 3-note sample was too short to be independently copyrightable, and even if it was, the Beastie Boys' use was de minimis. And we're talking about, this is a lawsuit from the musical composition holder, where this court is saying that, no, that was just a de minimis use. The court found that trivial copying does not constitute actual infringement under the copyright law. The court defined de minimis copying as that where the average audience would not recognize the taking or the appropriation. 3 notes was way too short for the average person to recognize that it came from Newton's song. The court noted that the Beastie Boys had a license to use Newton's performance, the sound recording. He just didn't have a license to use the underlying composition. Therefore, in order to be infringement, the sample had to be such that the average person would recognize that the notes were written by Newton, which is different than actual taking of the sound recording. This is different than the first case that we had. This is involving the underlying musical composition. So de minimis taking is okay in the sample recording. Now, the newest case from 2016 involves Madonna. And again, there's a video comparing these 2 songs as well. This case is also discussed at length in the book, page 388. And the case also describes in more detail the last 2 cases that I've talked about. So background on this case, the plaintiff, Salsoul, composed and recorded a song called Ooh, I Love It, Love Break. we'll just call it Love Break, Love Break included 2 different horn hits, which are chords played by a combination of horns. There's a single horn hit consisting of a quarter note, and this is background information that you kind of know when you go in and listen. You got to know what you're listening for. A single horn hit consisting of a quarter note, and 2, a double horn hit consisting of a 8th note immediately following the quarter note. So it's pretty quick. Both horn hits feature more than 20 times each in Love Break, and the duration of each single horn hit is 0.23 seconds. Very small. Salsoul owned the copyrights for both the composition and the song recording of Love Break. Several years later, Madonna records the song Vogue. Vogue used rhythmically similar single horn, double horn hits, although on different notes in a different key. In Vogue, many other instruments are playing at the same time as the horn hits, and other sounds like a cymbal crash are electronically overlaid onto the horn hits. Vogue's horn hits feature a total of only 6 times. Salsoul sued Madonna for copyright infringement, alleging that she had sampled Love Break's horn hits without their permission as the copyright owner of Love Break. And a couple other information, some other facts about this case is that the producer of Vogue admitted to copying the horn hit. He said he copied the 1/4 note of a 4-note chord, which lasted 0.23 seconds. He isolated the horns by filtering out the other instruments playing at the same time. He transposed it to a different key, and he added effects and other sounds to the chord itself. For the double horn hit, he used the same process, except that he duplicated the single horn hit and shortened one of the duplicates to create the 8th note chord from the quarter note. And finally, he overlaid the resulting horn hits with sounds from many other instruments to create the song Vogue. So, the court had to decide whether or not this was a de minimis copying. And now we're dealing with both the musical composition and the sound recording. And the court said the producer engaged in de minimis copying, and it is not infringement on both accounts. And this case comes out of California, our Ninth Circuit. Many of the cases we've talked about come out of the Ninth Circuit. The other cases were from the Midwest. I don't remember off the top of my head, from the Midwest. And the court said in this case, which is the latest case, 2016, a reasonable jury could not conclude that an average audience would recognize an appropriation of the Love Break composition. The horn hit is very short, less than a second. The horn hit occurs only a few times in Vogue. Without careful attention, the horn hits are easy to miss. Moreover, the horn hits in Vogue do not sound identical to the horn hits from Love Break. So, the question is, and it leaves open the question, surely the de minimis defense favorable that the copying here was less than a quarter of a second is what this note is. Still, as usual, we have no idea how much copying would cause the de minimis defense to fail. What if it's a half note? What if it's a full note? What if there's no key transposition? What if, how little is too little that gets over this defense elsewhere, because a court elsewhere could decide differently on the same case and the same notes. So anyway, listen to the songs. The Madonna song, if you open up the book, it'll tell you exactly where the notes are hit. Otherwise, you're going to be listening to the whole songs, which is fine. You want to listen to the whole songs. I don't think you hear the first. I'll tell you where the first one is. On Salsoul, the first hit is around 3 minutes and 11 seconds in. The other one's at 4:38. Fourth one's at 7 minutes and a second, and then 7:45. They kind of play in between those. There's 20 times it hits. It plays between those times. On the Madonna song, the first time you're going to hear it is at about 56 seconds in, and then 102. You'll hear the horn hit at 56 seconds, and then you'll hear the double horn hit at 1 minute and 2. It's very fascinating. So this wraps up our points relative to musical compositions and sound recordings. I am going to talk more about this as we roll into infringement in a couple weeks. Our next topic is fair use, and so this will intertwine some of our discussion here as well. So fair use and infringement, we'll continue our discussions regarding musical compositions and sound recordings, as well as other works, when you can use them, when you can't use them, and the very gray area that exists in fair use. But nonetheless, watch the other videos. The assignment involves watching that documentary. The quiz is going to involve a question tying in these 3 cases.